Hey guys, happy Wednesday. It's my Tuesday tip, sometime Wednesdays. This time it's coming to you on a Wednesday. And my handheld guy is charging and it was out of juice. And I waited for it for a little while and decided, you know what, I'm just going to go ahead and hold it the old fashioned way like we used to do. So I got a question today from an old friend. Can an employer fire you because of your use of social media? Well, as is a typical lawyer answer, the answer is, well, sometimes. So first of all, got to remember in the state of Illinois, Illinois is what's called an employee at will state, which means an employer can basically fire you for whatever reason they want. If they don't like your haircut today, then they can fire you. Now, there's going to be some exceptions to that. If you fall within protected classes or under certain situations, or if you filed a workers' comp case. But generally speaking, an employer can get rid of you anytime they want. So when's a period of time when they can for sure fire you as a result of social media activity, even if your social media activity isn't related to the employer, and even if nowhere does it even say that you're related to the employer? Well, number one, if you engage in any activity that is harassing, intimidating, or threatening to another employee, that's grounds for an employer to terminate you for sure. If you're violating a policy with regards to social media, so if your employer has a policy that you're never to be on social media during your time in employment, even on a break or whatever, if you violate that policy, then they can terminate you. If you do something that tarnishes the employer's reputation in some way, and that's kind of subjective, that's one that's kind of up to the employer, and they should have a policy with regards to this, but if they make a determination that something you say somehow tarnishes them, so, the obvious one is you put up a post that, my job sucks, or this employer sucks, or they don't do what they're supposed to, that's pretty obvious, but if you put up some other stuff, it can be a little bit less than obvious. What actually tarnishes their reputation if it doesn't say anywhere that you work there? So clearly, if you mention them, well, then that's easy. But if you say something a little bit more subtle, then that could be a little bit more complicated. Divulging confidential information. So if you put up on Twitter, hey, Martha Stewart, you're going to want to sell that stock because the company's going to divulge a bad quarter. Okay, well, you now divulged confidential information, and so the employer can clearly terminate you for that. And that can be like, anything. If you work at a school and you put out there that something happened bad, whatever. Any type of information, you owe an ethical obligation to your employer for a sense of loyalty and duty. That happens with every employee. So you have to operate, especially when you're working for your employer, at what's in their best interest. So if you somehow violate that using social media, then that's grounds to terminate you. Also, if there's something that proves that something that you told the employer is a lie, and you did that on social media. So if you called in sick and you went to a Cubs game with Ferris Bueller, and you pop up on social media that you're at the Cubs game, you check in at the Cubs game, which I'm sure that there's employees that do something that kind of ridiculous. And if you do that, then the employer can say, well, based upon your social media, you checked in and you weren't sick, and so I can go ahead and terminate you. So when is there grounds where they can't do it? Well, some posts are protected. There are times when somebody can do a post, and there's specific things that are protected. There's a federal piece of legislation called the National Labor Relations Act, and it covers things called concerted activity, and that's a term of art. And what concerted activity means is if you're discussing work conditions with another employee and it's relevant to your job. So even if it's negative. So under that act, the National Labor Relations Act, you have the right to do certain things as an employee. And so one of them could be if you are alarmed at an employer's conduct, you could discuss that with another employee, and you could do that on social media. You could be messaging each other on Facebook saying, hey, what we're doing here is illegal, or what we're doing here is unethical or dangerous or something like that. How do you feel about that? that's going to be protected activity because it's going to be considered concerted activity under that National Labor Relations Act. And there's going to be a lot of things that fall within that. A lot of that, though, is going to be a communication with another employee, or like with a lawyer, or maybe even a spouse, or a friend that might have information. But it's got to fall under that concerted activity idea. If the employer has a written policy and doesn't follow that written policy, then they cannot terminate you for using social media. So like, let's say that they have a written policy that you're never to use social media while you're employed, but you're supposed to get a warning and then a letter of whatever, and then they fire you on the third time. And you write something and they fire you on the first time. Okay, well, they can't do that. They got to follow whatever their policy is in terms of getting rid of you. So then you got to get your job back, and then probably they'll find another way to fire you. But if they have a policy, they have to follow the policy. There are other areas of protected activity. A whistleblower. So if you're notifying people that, hey, what's going on here violates the law, and you throw that up on Twitter, they can't fire you for that. That's protected activity. And then in some states, there's other activity that's more protected than in the state of Illinois. So there's going to be states out there that say, if you're discussing politics, that's a protected activity under the First Amendment, and you can't be fired for that. If you're discussing Freedom of Information Act information, if you're discussing age issues, health issues, I mean, there's going to be states that have different regulations. Illinois is not one of those. Illinois is, again, an employee at will state, so Illinois, you can be fired for any reason, so that type of stuff doesn't apply. So the big thing is, you owe an ethical obligation to your employer to act in their best interest. You do not have to do that if it violates the law. You do not have to do that if you're concerned about the activity of your employer, and that's legitimate. If your employer has a policy, they have to follow that policy. But if they find on social media that you're lying or you're bullying somebody else, well, then they can terminate you, but not if it's a whistleblower situation. So that's kind of a summary of the situation. So the best advice, don't use social media when you're at work. If you're an employee, stay off of it. You're a lot more productive. It's a lot better, and it's easy to track if you're an employer. If you're an employer, have a policy. And the policy probably would make sense to be, don't use social media when you're at work, unless it's something specifically for work, in which case that would be different. Hope everybody has a great Wednesday, and I hope everybody enjoys the Tuesday tip. Have a happy and safe Halloween, everybody. Watch out for kids while you're driving on the road.